the new kind of, I guess, presidential memorandum that came out regarding the overstay rate and what President Trump intends to do to reduce it, as well as, it's hard to believe, it's already been 2 years since the Buy American, Hire American executive order. And so we'll kind of discuss what changes we've seen since then and how the immigration landscape has changed, especially for employment-based immigration. We wanted to talk a little bit about visa stamping and how to prepare for the interview, what to expect during the interview, so that you can have your best chance of success. And then we also wanted to today discuss H-1B amendments and the requirements for filing that, specifically under the matter of Simeo guidance, as well as just in general, what triggers the need to file an amendment, when it needs to be filed so that you and your employer can remain in compliance. So I guess first let's talk a little bit about Buy American, Hire American. Last week, USCIS actually held a stakeholder call to discuss kind of what's been happening with Buy American, Hire American, and get public feedback from the whole, I guess, initiative. And Rebecca listened in on that call. Can you kind of give us some insights?
Sure. So the Buy American, Hire American executive order was issued almost exactly 2 years ago this month in 2017. And as many of you know, it sought to basically increase wages and employment rates for U.S. workers by rigorously enforcing the existing immigration laws. And so the executive order itself didn't contain many specifics. It was mostly a directive to heads of various agencies involved with the immigration system to implement policies in line with that goal. So over the past 2 years, if you've been keeping up with us and listening in on our conference calls, you are aware that there are many policies that have significantly changed, at least employment-based visa processing as a result of the Buy American, Hire American executive order. Some of those include the rescission of the deference policy for non-immigrant visa extension applications. So an extension application is now treated as if it's a brand new application, even if you've had multiple H-1B visas approved in the past. Your extension is not guaranteed to be approved, even if there's been no change in your employment terms. Other initiatives that are part of the Buy American, Hire American executive order are the February 2018 third-party placement memo, which has made it almost impossible to get an H-1B visa approved for a third-party placement situation unless you have all the contracts, letters, and various other supporting documents for every link in that contractual chain. Those are from USCIS, but other areas where the policy has been coming in is for DOS, which manages the consulates, and the consulates have been specifically instructed to keep the Buy American, Hire American executive order in mind when processing visa applications. And also DOL, which in the past year has released a new form for the LCA, which is part of the H-1B visa application. In addition, of course, in 2017, we started seeing additional scrutiny for any wage level 1 visa applications. So those are just some of the effects of the BAHA order from a couple of years ago. And in order to commemorate the second anniversary, USCIS held a listening session last week, and there were a lot of the agencies were involved. There was Director Cisna, who is the director of USCIS, was on the call, as well as the Deputy Assistant Attorney General from the Department of Justice, officials from the Wage and Hour Division at the Department of Labor. And the session in the beginning mostly was the heads of these various agencies reviewing the steps, the policies, and initiatives that they've implemented in their various departments in order to comply with the Buy American, Hire American executive order. The listening part of the session, in which ostensibly it was comments from the public for the heads of these various agencies concerning how the Baja order is being implemented, it was pretty one-sided from what we could tell. Mostly the comments were along the lines of the implementation of Baja is not being carried out well enough. The comments from the public were basically that the agencies needed to do more to enforce Baja. A particular issue that seemed to come up more than once was concern for H-1Bs and other types of non-immigrant visas. Part of the process is, of course, the LCA, where DOL needs to ensure that the wage being offered to the foreign worker is at or above the prevailing wage, which is published each year by the Department of Labor on its FLC data website. A lot of the comments were along the lines of those prevailing wages not being high enough or not being an accurate reflection of what actual wages are in the marketplace, which for those of us actually practicing in this area who have seen dozens and dozens of prevailing wages for various applications all over the country, that's not necessarily the feedback we get from employers, many of whom employ other American workers, and sometimes we have to tell them the prevailing wage for this H-1B worker that you want to sponsor is significantly higher than what you're offering him and other similarly situated workers who sometimes are U.S. workers. So we don't know how that will pan out. My estimate, actually, after listening to that session, is that we may be seeing more along those lines of DOL maybe looking into increasing the prevailing wages. That would be one potential way that they can implement that order, and that would affect a lot of visa applicants without a significant change in the law, just in how DOL calculates those prevailing wage calculations. So we'll have to see, but definitely it wasn't very encouraging. It's definitely along the lines of the trend that we're seeing. A couple weeks ago, we discussed the resignation of the DHS Secretary, Kirstjen Nielsen, which was largely considered to be because the president doesn't believe she's being tough enough on immigration. That was sort of the tone of this call as well. So in the coming up, unfortunately, it seems like it's going to get more and more difficult before it gets better.
Wow, that's very uplifting. Yeah, definitely. I think that Buy American, Hire American. We do have more statistics now than we did before. Mm-hmm. We have the Employer Data Hub. We also received just updates on more information about the employers that were filing H-1Bs. And also with this new LCA, especially where it's third-party placement situations, they added a section where you're required to specify the name of the end client where you're working at. So I have a feeling probably within a year we'll see that information coming into that data hub from Buy American, Hire American. Yeah, so always something, I guess. So one of the other big topics this week was the president's memo on overstays. So it's long been discussed that part of our undocumented immigrant problem is not just the southern border and people entering without inspection, but it's also people who are coming here legally and then overstaying and not leaving. And so now the president is preparing to address that situation, basically directing agencies to take a look at the countries that have the highest rates of overstays for B1 and B2 visas, as well as the visa waiver program, and look into options for limiting those visas. So they might limit the number of people that can receive visas from those specific countries, or reduce the time that you can stay on that particular visa, or limit the amount of times you can enter using that visa. And so that's kind of where we're headed for B1 and B2 type visas. And then, there's even some discussion about what they call admission bonds for these
Right.
countries, where basically the idea is you kind of pay a deposit
Yeah.
and in order to get the visa and travel, and then once you successfully leave on time, you'll get your deposit back. So that's kind of something new. And we don't know how all of that's going to work or when that could be implemented, but just be aware that even the B1 and B2 is likely to see some changes soon based on this new memorandum. A couple other things we wanted to talk about are just the visa interview process. If you're going for stamping, we know that 221Gs and administrative processing is becoming more common. It's taking longer to get the visa stamp. What can you do to try to avoid that situation? I think the best thing is to prepare with all the necessary paperwork for your visa interview, especially reading through the petition that was filed on your behalf so that you're clear on what was said and you can ensure that what is actually happening is consistent with that, so that when you're answering questions to the consular officer, everything lines up. Of course, it has to be accurate. But that's one of the things that kind of causes interviews to go bad, I guess, is when you start answering things that aren't in line with what's in the petition. And then a lot of the 221Gs tend to be for third-party placement type situations where they are, even if you have the necessary end client letter, what we're seeing more and more often is that letter being referred to the Kentucky Consular Unit's fraud detection. I don't know what the proper term is for a unit, I guess it would be. And that organization is within Department of Homeland Security. They actually reach out to the person who drafted the letter with a copy of what they were given and ask them to verify that they did in fact write the letter and ask whether any modifications have been made to it, because consulates are finding that people are modifying documents and submitting them to USCIS, submitting them to the consulates. That's a huge problem if that's happening. Definitely can subject you or your employer to revocation for misrepresentation, can cause a ban from you being able to get the visa. So certainly don't engage in any kind of those practices, but that is one of the reasons why so many 221Gs are happening, why it's taking so much longer. Even for legitimate situations where there's no problem with the documentation, you've got to go through that process too, because others have unfortunately kind of poisoned the well, I guess, on that. So do you have any other suggestions for people to how to prepare, what the interview's like, what to expect?
So definitely preparing for the visa interview starts well in advance before your trip. It starts with, like Emily said, reviewing your most recently approved visa petition and ensuring that your terms of employment are accurate, that your current terms are those that are listed in the petition. If they are not, then you need to contact your attorney and your employer to file an amendment application, especially if the change in employment terms is a change in work location to another city. That's a situation where you definitely need to have had an amendment filed, even if the change is to a different end client, for example, in the same city. If there's been a change in project documents, a change in vendors, the consulate is going to want an amended petition filed for that before you go to the visa interview. And then at the actual interview, it is pretty unpredictable. The consular officers have a pretty wide range of discretion in what they ask, and like we mentioned earlier, the Buy American, Hire American executive order has kind of trickled down to the consulates to the point that they're asking some questions that are not always appropriate and not always relevant to the H-1B visa application. We recommend definitely preparing by contacting and consulting with an attorney beforehand. Definitely helps so that you're not caught off guard in the actual interview. And then Also, just build in extra time in your trip. Assume that you're going to get a 221G, which can take a couple of extra weeks to process if they're doing independent verification with your employer or end client, and just anticipate that so that you're not as anxious if you do get a 221G.
Yeah, and one of the other things that President Trump specifically has introduced is this idea of extreme vetting.
Right.
So there are some situations where people who've applied for the visa are asked to fill out this extra application form that asks for like 15-year history
Yeah.
of employment, education, social media handles, and all of that. And so we don't really have a lot of information about how that process is going once you provide the additional information about how long it takes. There's just no real data out there that we're aware of. So hopefully we don't see the use of this extreme vetting really spreading. I don't hear about it every day, but we are hearing about it.
Yeah.
So once we start seeing more or getting more feedback from people on that, we'll certainly be discussing it more here to let people know what to expect and what's going on, how long it's taking with that extreme vetting initiative. And you mentioned the situation where maybe things have changed from what's in the petition versus what's going on now and the need to file an H-1B amendment. So that's one of the topics we wanted to talk about today is what causes the need to file an amendment and when does it have to be filed. So there's kind of the general rule is any material change in the terms and conditions of employment requires an amendment to be filed, and the amendment is required to be filed before the material change takes place. So common material changes would be a promotion where your job duties have changed materially, a decrease in salary, a decrease in hours going from full-time to part-time, or the opposite, going from part-time to full-time, and then changes in work location where it takes you outside kind of the main city where your petition was approved for. Those are the basic situations where an amendment must be filed, but anytime there's some kind of change that's happening, you should definitely reach out to your immigration attorney to verify whether it rises to the level of a material change requiring an amendment to be filed. The other kind of basic rule of amendments is the matter of SEMEO guidance, and so that says if your work location has changed to a new place where a new LCA is required, that new LCA is considered a material change and therefore an amendment has to be filed. And I can't stress enough that the amendment has to be filed before you can start work at the new location, before the new terms and conditions take effect. If you can't start at a new location and then a month later file the amendment, you're risking your amendment getting denied and a finding that you violated your status, your employers violated the H-1B requirements, and it puts you out of status. You may have to exit the country and wait for another amendment to be filed, approved, and then come back in, possibly get a new visa stamp. It's a huge hassle when the amendment timing is not done correctly, when the right thing to do is get it filed first and then start the new terms and conditions. So I just want to reiterate that because we see a lot of situations where terms and conditions of employment are changed and the amendment was never filed, and then we've got to figure out how to cure it, and there really is no way to cure it other than having you leave and then filing while you're outside the U.S. So people generally don't want to stop working and leave to cure it properly, so best to just avoid that situation altogether. All right. One of the questions we get a lot is updates on the H-4 EAD. Last I checked, there were no changes on that. It's still pending with the OMB. We have no idea when the OMB is going to finish their review and when an actual proposed rule will be published. Once that happens, then we'll have a better idea of the expected time frame and what might happen with existing H-4 EADs. But for now, you can still file and continue to get those approved.
So Shashidar has a question about H-1B transfers. Once an H-1B is transferred to a new employer, can we work for both the old and new employer at the same time? Not if it's filed as just a normal transfer requesting a change of employer and extension. There is an option to file for concurrent H-1B employment, which would allow you to work for two different H-1B petitioners at the same time. However, the new company would need to select concurrent employment on the I-129 form. If they have not, you don't necessarily need to transfer over to Company B, for example, right away upon approval of the transfer. You can, but you don't have to. You can continue working with Company A as long as their approval notice is valid for you, and then switch over to Company B when you're ready. But you can't work for both at the same time unless concurrent employment has been selected.
So Rob from Facebook wants to know if an H-4 holder who does not have an EAD can invest in the stock market. Absolutely. That is considered passive investment, where all you're doing is putting your money in and hoping someone makes a profit so that you can earn some money, interest on that. You're not actively involved in the companies that you're investing in the stock market. So definitely no problem with doing that even while you're on H-4.
There's a question about when premium processing will be open for consular processing. I assume that means for applications filed in the H-1B CAP. And I believe USCIS has stated that those will be available in June, most likely. I don't think they've given an exact date yet. The only exact date that they've given is May 20th as the start date for the premium processing clock for change of status applications that have been selected and were filed concurrently with a premium processing request. But consular processing, no exact date yet on when you can upgrade to premium. They've just mentioned sometime in June.
Sandy has a question for an H-1 extension application. If you have a great end client letter that has all of the information, this is a third-party placement situation, is it still mandatory to have the actual contract or master services agreement and the statement of work? Yes, I'd say 99% chance if you don't submit that, you'll get a request for evidence asking for it, even if all of the information is provided in end client letter. USCIS is definitely reading through all of that. We a lot of times will submit redacted versions of those documents because the end client doesn't want to share all of their confidential information, and that used to be okay, and now we start seeing requests for evidence asking for non-redacted versions of the documents, even when the redacted section is completely irrelevant to the adjudication of an H-1B. So yes, I would definitely plan on having to submit the statement of work and MSA to get that approved.
Sri Kamal is asking, can an H-4 visa holder do unpaid research or lab training in a nonprofit hospital? So, yeah, so that's a good question. Definitely, if you don't have an EAD, then H-4 visa holders are not authorized to work. And so we do get that question a lot. Can I volunteer? If I'm not paid, can I do this without an EAD? The general rule that we kind of give is that if it's work or if it's a position that someone normally would be paid for, then you should not do it, even if you agree to receive no compensation. Just because you're not being paid doesn't mean it's not employment. So if it's truly a volunteer activity that with a religious organization or a charity or some event where everyone else doing the same thing you're doing are also volunteers that are not being paid, that's fine. But I would say something like this, research or lab training, sounds like it's verging on employment towards something that you would need work authorization for. So I would avoid it.
Suba has a question on Facebook. The H-1B that's pending was transferred to a different service center, and they tried to upgrade to premium processing, but that was sent to the old service center. How will USCIS handle that? In the old days, I'd say they'd probably transfer the premium to the new service center for you and do you a favor. These days, probably not. I would expect it'll probably be rejected back and you'll have to refile it. And that takes about 2 weeks typically when any application that's been filed is not properly filed and they reject it. It takes about 2 weeks to get it back in the mail, unfortunately.
So we have a question about someone leaving their current H-1B employer, and the employer is asking the beneficiary to pay back the fees that the employer paid for the H-1B, filing fees, legal fees, probably. That is not okay. So an employer is required under the law to pay all the costs associated with an H-1B visa sponsorship. The only exception possibly is premium processing because it's optional, and if it's the employee requesting the premium processing, that might be okay for an employee to pay for it personally, but otherwise anything else related to the H-1B visa sponsorship has to be paid for by the H-1B sponsoring company only, and they are not allowed to require the beneficiary to pay back or reimburse the company for that amount.
Yeah, so you could definitely file a complaint
Yeah.
with the Department of Labor for that on the WH-4 form if you wanted to. Question about the receipt notices for the H-1B cap. So I do update those daily with Monday through Friday with the progress of what types of receipts we're getting, what percentage we've gotten for the cases we have filed. So we didn't receive any in the mail today. We didn't receive any email notifications today either. That doesn't mean it's over with. Probably over the Easter holiday, things slowed down a little bit. I expect we'll have a lot more in the mail tomorrow. And so for the advanced degree applicants who filed in premium processing, I think we're around 64 to 66% is what we've received so far. I kind of was expecting that to go up to 70 to 75%, especially given the change in the lottery order. So I don't think it's over for premium processing yet, but we are probably getting close to the end. For non-premium processing advanced degree, we did start getting a couple of those by snail mail. So we're just at the very beginning. I think maybe 3% is all that came in. So that number should match the premium processing for advanced degree. So if we've only got 3% in, that number should go up to at least 64 to 66%, if not 70 to 75%, which means we've barely even started the non-premium processing for the advanced degree. So Raja, hopefully that answers your question. We're just at the beginning. I would expect more to be coming in for that particular category. Yeah, it's going to take time. I mean, we keep getting receipt notices until about May 15th, so it's not a fast process.
Ava has a question about work authorization while he or she has their I-485 application filed and pending. So it looks like they're working based on an H-1B right now, but the EAD is on the way if you have the I-485 filed and pending. And whether to basically maintain the H-1B or abandon or withdraw it once you receive the EAD. So our advice on this situation has changed a bit in the past couple of years, the past year or so especially, I would say. It used to be that we didn't really think that maintaining the H-1B or other non-immigrant visa was particularly necessary once you received the EAD card associated with the adjustment of status application, because the EAD allows you to work and you usually receive it along with an advanced parole, which allows you to travel, and you wouldn't need the H-1B anymore. With the issuance of the notice to appear memo or guidance from last summer, the notice to appear memo specifically identified denied I-485 applications as a situation in which USCIS would could issue a notice to appear to the applicant of the I-485 application. And a notice to appear is basically the initiation of removal proceedings. It's a notice to appear in immigration court. Because of that guidance from last year, we have been advising that people maintain your non-immigrant visa status alongside your EAD and advanced parole, if possible, until you receive the green card. Because if something, for some reason, goes wrong with your I-485 application and it's denied, if you have your H-1B visa that's approved and you're maintaining H-1B status, you will be okay. You can remain in H-1B status and look into filing an MTR for the I-485 or otherwise fixing the I-485 situation, and you will not be issued an NTA. So I would recommend, if possible, to continue the H-1B if you can.
Dinesh has a question. Do we need to file an H-1B amendment if we're in the same MSA and we're planning on going for stamping? So that's where it's a little bit of a gray area, because the matter of Simeo guidance says no, because you're in the same MSA, and amendment would not be needed as long as the other terms and conditions of employment have not changed. At the same time, consulates, when you show up with a new end client letter and a different vendor and different documentation than what's in your petition, they're going to say, why didn't you file an amendment? Your project has changed. That requires an amendment. It's a material change. So if you are going for stamping and the reason your location change happened is because your project, your end client that you're working for has changed, we would recommend filing an amendment in that situation. If the work location change within the MSA is just because your company moved from one location to another location, then I don't think an amendment is necessary, even if you're going for stamping. That can just be explained in a letter of support from the company. But if it's due to a change in project, change in end client, to where you're working for a completely different end client, they're expecting that the whole employer-employee relationship and right to control needs to be reestablished and approved by USCIS before you can get the stamp.
Sanket has a question about an H-1B and H-4 extension that were filed concurrently in premium processing last month, and the H-1B is approved, but they haven't received anything yet for the H-4. So yeah, that's most likely due to the new biometrics requirement that we've been discussing the past few weeks. If it was filed after that requirement came into effect, then the H-4 is going to take longer than the 15-day processing time to get approved because of the additional fingerprinting requirement. If you haven't received anything at all on the H-4, you may want to try to see if you can check your bank records to see if the H-4 filing fee check has been cashed, just to make sure it was properly receipted and that it is in process. If that's the case, then it may just be a mailing error with the receipt notices. We have been kind of anticipating some errors or delays with receipt notices and biometrics notices being sent.
Question from Facebook. Can you enter the country if you have a 221G that's pending, but you have another type of visa that's still valid? Short answer, it really depends. So in the specific example, they mentioned possibly coming on a visitor visa while you've got a 221G pending. That makes me very nervous that you probably won't be allowed into the country at the airport, even though you have the valid visitor visa, especially if your 221G is pending for an employment-based visa. So if you have an H-1B that's stuck in a 221G and you try to show up at a visitor visa, chances are at the port of entry they're going to say your intention is clearly to work, and you're using the visitor visa as a way to come in here and work without authorization. So that won't work. At the same time, if you had maybe an H-4 that's still valid, your spouse is still in the US, still maintaining H-1B status, and you don't intend to work when you're coming in on the H-4, you may be able to come in on an H-4 while your H-1B is in 221G, maybe. There's nothing specifically saying you can't, It's all about, can you prove to the officer at the port of entry that your current intention in entering the country is consistent with the type of visa you're entering on. So it's a big risk to take to try that. It may not be worth it and might be better just to wait until the 221G processes or withdraw that application for the visa and then choose to come back on whatever visa you have available.
So someone has a question on traveling internationally while they're on their STEM OPT for 4 weeks unpaid. Will it be counted as unemployment? So yeah, you definitely have to be very careful with any time spent outside the country during your initial OPT or STEM OPT period of time, because any time you spend outside the U.S. can be construed as unemployment time, and you have a limited number of allowed unemployment days in both the initial 1-year OPT and cumulatively for the 3-year STEM period. 4 weeks sounds like quite a lot. It depends ultimately on how much unemployment time you've already had in your total 3-year period. I would definitely discuss with your DSO and make sure you're not going over the unemployment day limit before you travel.
Sarvani has a question on Facebook. Can an H-1B holder start a business and work for it? Unfortunately, in most situations, that answer is no. Really, the United States is behind on that because we don't really have an entrepreneur type visa that allows you to start a business and work for it. The reason that you can't do it on an H-1B is because the H-1B has to have an employer-employee relationship where the company controls you, the H-1B employee. Now, if you're the company and you're the employee, you're basically employing yourself. It's self-employment, and that's not allowed on an H-1B. The only way to really make it work is if someone else owns more than 50% of the company and you have some sort of board of directors, or you can demonstrate to the Immigration Service that are other people that control you, even if you are a partial owner within that company.
Let's see. So we have a question from someone who is considering changing from H-1B to H-4 status and previously had an approved EAD when they were previously in H-4 status, and asking if they can continue to work using that EAD, or do I need to reapply for a new EAD? I believe you will need to apply for a new EAD. When you changed the first time from H-4 to H-1B, that EAD that you had from your H-4 status is no longer considered valid. So if you're changing again now back from H-1B to H-4, you will need to apply for the EAD card again.
Sorav has a question. Change of status from F2 to H4 has been pending for 199 days, ridiculously long amount of time. Is there any way to fast track the process, other way to get it approved faster? Not as a change of status with USCIS. There's no premium processing. I think 199 days is still considered normal processing time for an I-539, which is ridiculous. You can exit and apply for the H-4 visa stamp at the consulate and come back in. That would probably be faster. Possibly, depending on whether you're still maintaining your F2 status, which I'm guessing probably no. I'm guessing your spouse probably changed from F1 to H1B, and that's already taken effect. So now there's you're basically in a period of authorized stay. You can't really refile with an H-1B to make it go faster. So really, your best option is to travel and get the visa stamped if you're looking at speed, if that's the most important thing to you, unfortunately.
So we have some questions about traveling outside the U.S. during the cap gap. So the person asking this question seems to understand that if, since they filed in the quota as a change of status, because the cap gap is only eligible for change of status requests, that once they leave the U.S., they'll be considered to have abandoned the change of status application. So they're asking if they can just wait outside the U.S. and apply for the visa stamp eventually if and when their H-1B application is approved. So that is doable if you are okay with remaining outside the U.S. until the H-1B application is approved and the approval notice can be sent to you abroad, and then you take the approval notice and the documents and apply for the visa stamp at the consulate and then come in on H-1B. That's definitely an option if you are okay with waiting outside the U.S. until it's adjudicated. It's a little bit more possible, I would say, this year than in the past couple of years, since there is premium processing. So you can always upgrade to premium to make sure you try to get a decision by October, so you're not just indefinitely outside the U.S. I would say the only thing to keep in mind is that if a request for evidence is issued, normally it is much easier to respond to a request for evidence if you are here in the U.S. actually working for the U.S. petitioner. That's definitely the case if it's a third-party placement situation, because most of the time RFEs are about confirming your work at that end client site. But even if you are working directly for the U.S. petitioner, a lot of RFEs now are asking about specialty occupation of the proposed position, and one of the easiest ways to prove up specialty occupation is to provide a detailed list of your job duties and maybe examples of your work product to show that you are performing these duties and that they meet the level of a specialty occupation. So that's the only thing I would keep in mind, but otherwise that would be doable waiting outside the U.S.
Surjit has a question about RFE responses and how those are submitted to USCIS. Is it a soft copy or hard copy? So if it's regular processing, the only option is to mail a hard copy to USCIS. But if it's premium processing and the response is, I believe the limit now is 15 pages or less,
Yeah.
your employer may be able to fax the response. But we typically mail all of ours hard copies to USCIS because our responses are 99% of the time more than 15 pages. Saurav has a question about H-4 biometrics. When is it required? How long is it taking once the receipt is received? So the biometrics is required for every single time you file an I-539 application going forward. So if you are applying for the H-4 at the consulate, there's no I-539, so there's no biometrics. Of course, unless you're going to one of those application support centers outside the U.S. to get that done as part of your visa interview process. But the I-539 filing with USCIS is what triggers the need for the biometrics. It's taking, I would say, I'm trying to think if we've had any regular processing that have come in lately. I know with the premium processing, we got the biometrics notice right around the same time we got the H-1B approval that the H-4 was filed along with. I had one for an F-1 not too long ago, and I would say it took maybe 3 weeks to receive that as well. Once the biometrics are done, we don't know how long it will take to get the approval. We should be finding that out very soon, as our first kind of round of people had their biometrics appointments last week. So we are keeping tabs on that, and we'll let you know kind of what to expect in terms of processing, especially if yours is connected to a premium processed application. But if it's a regular processing, regular H-4 filed by itself or an F-1 filed by itself, the biometrics really shouldn't be adding much to the processing time because the processing time is already super long.
Yeah.
So that's kind of what we're seeing right now on that.
We have a question about what majors might be appropriate for day one CPT. It's going to be very limited, so if you've watched our videos before, have been kind of following our blogs, you know that we recommend against some of these kind of F1 CPT, day one CPT programs that will allow you to enroll basically at any time during the year and issue you immediate work authorization. Those programs are very suspect, and they are definitely on the radar of DHS for investigation. The Day 1 CPT exception is really a very narrow one that's only intended for a small percentage of majors that do require hands-on work experience during the first year of study. The examples that we've given in the past include like medical residents or nursing students who need to do rotations, that sort of work. I would say the majority of the types of programs that Day 1 CPT is being issued for these days usually don't really meet that exception. And so unless you are in one of those very narrow areas of study, I would avoid Day 1 CPT if you can.
Anand wants to know if you can apply for the H4 EAD renewal along with an H1 transfer if the EAD is still valid for more than 6 months. Yes, you can. We do that quite often to try to get that extended validity on the H4 EAD and haven't had any issues with that yet. Venu has a question. He filed a change of status from F1 to F1 from B1 and needs to go for stamping now. He wants to know if he has to go to his home country, if he can go to Mexico. If you entered on a B1 and changed your status to another type of visa, you're not eligible to go to Mexico or Canada. You have to go to your home country for that to get the very first visa in that category.
Shivam has a question. It looks like he has an H-1B petition that's pending, but now his employer wants to transfer him to another work location. And what are his options? So if that other work location is outside the MSA that was covered by the pending application, like we discussed earlier, that's a situation that will require an amendment to be filed. There isn't really a way to update or revise the LCA work location for a currently pending application. So your employer will need to file an amendment for the new work location. It would be best if the current pending application, depending on where you are as far as your I-94 expiration date, if you're past your I-94 expiration date and this is an extension, I would definitely upgrade it to premium processing to get it approved before you change work locations so that you can get the approval and then have an amendment filed and then move to the new work location without jeopardizing your status.
Priyanka wants to know if the biometrics are needed if you're applying for a change of status to H4 with the H4 EAD if you're already on OPT or with the OPT extension. Yes, because the H4 change of status requires an I-539, you'll have to do the biometrics. Even if you've done biometrics before or recently or at the consulate, you still have to do them when you file the I-539.
Vijaya is asking our opinion on the SOC code for 151311. I think she might mean 1133 for computer programmers at a level 4 wage. Is that going to be considered a specialty occupation? It's hard to say for sure. It says here that the job title is project manager. There are other titles or other SOC codes available that would be a fit for a project manager role. There is an SOC code for computer and information systems managers specifically, and if your wage is high enough to be considered level 4 under a computer programmer, it may meet the threshold for that SOC code. I would lean towards doing that, looking for another SOC code where your wage level is maybe at level 2 rather than a level 4 computer programmer. A computer programmer as an SOC code has been singled out specifically by USCIS as not a specialty occupation.
Rakesh wants to know if someone can file for the I-140 and the H4 EAD at the same time to get the EAD faster. Unfortunately, no. You have to have the I-140 approved first and then file the H4 EAD after that. And the H-4 EAD can only be obtained in premium processing if it's filed along with an H-1B.
So a boss has a question. He has an H-1B and an I-140 with one employer. If he switches employers, does he need to have an I-140 approved with the new employer in order to file for an extension of his H-1B past the 6-year limit? And it says his I-140 with his current employer was approved last May. So in that case, you don't need an I-140 approved with your new company first before filing for the H-1B extension. So after January 2017, if you've had an I-140 approved and it's remained approved for at least 180 days, even if it is withdrawn by that petitioner after 180 days, that approval notice remains valid for purposes of filing an H-1B extension beyond the 6-year limit with a different company. It doesn't need to be with the same company. You'll also be able to preserve and port the priority date from that first I-140 petition.
Kushal wants to know when the H-1B stamping has to be done after your H-1B is selected in the lottery. When's the latest you can get the stamping done? So the validity of the petition, the approval, is what determines the very latest you can get the stamp. So if you have a 3-year approval, technically you could go anytime during those 3 years to get the stamp. At the same time, practically there's some risks in waiting. That job might go away and you might not be eligible to get that stamp anymore. And especially if you're outside the U.S. and you're waiting for some reason in order to come into the U.S., just circumstances change. So definitely the earlier the better in terms of getting the visa stamped if you require a visa stamp once you have your approval. Another question from Facebook: how long does it take to get a decision after submitting an RFE response and regular processing? I'd say right around 60 days, maybe a little bit longer. That's pretty standard these days.
So someone waiting for their green card interview is asking if they can change their address to a different state. Only if you are actually moving to a different state. So definitely green card interview dates and how soon you get scheduled for the interview can vary widely depending on your city of residence, because that final green card interview takes place at the local USCIS field office, and different field offices have different levels of backlogs. Houston, for example, has unfortunately one of the largest backlogs in the country. So unfortunately, just depending on where you live, it can take several more months for you to get scheduled for that final I-485 interview. But you should not change your address just in order to try to get an earlier interview date from a different field office. If your employer actually is moving you to a different branch office or something like that, and you're really moving for employment reasons or other reasons that won't jeopardize the I-485 application, yeah, you can definitely move to another state and make sure you file the AR-11 form for change of address. That's very important when you have a pending I-485, so they know where to send your interview notices, your biometrics notice, RFEs if there are any.
Surjit is working on an RFE response for a specialty occupation type RFE with his employer, and they've come up with a job description that is now 28 pages long.
Really?
And wants to know if there's an issue with that. Technically, no. I mean, there's nothing wrong with that, but I guess I don't think I've ever had one that long. I think my maximum is probably 15 pages.
Okay.
And that was pretty long. And you just have to be careful that you're not overwhelming the officer and you're not making it jumbled and less clear. Right. Sometimes being brief is better. I'm not saying you can't or shouldn't submit a 28-page job description, but I would definitely take a look at that again to see if there's a way to say the same thing more briefly, because I think the longer doesn't necessarily make it better. It might just be more confusing.
Yeah, you definitely want a sufficient level of detail in the job description. We've been emphasizing that for a while, and definitely it sounds like that's what this person is trying to do, including enough detail in the job description to show it's a specialty occupation. But yeah, definitely if it is a specialty occupation, I feel like the officer should be able to grasp that in probably something shorter than 28 pages. Yeah, see if you can find a way to get it across more concisely.
Kushal wants to know if there's a job title change, does that require anything to be filed with USCIS? If it's just the title that's changed, maybe there's a restructuring going on or reorganization and the company's changing its job titles. If nothing else has changed, no, an amendment does not need to be filed for just a job title change. If job duties also changed, that's where you need to look at, okay, is it changed enough to be a material change, and then it would require an amendment.
Suresh is in F1 status and his application was selected in the lottery. And he's asking what will happen to his SEVIS record in the portal, when will it update? So I believe if it's filed as a change of status, SEVIS will update to show that an H-1B application is pending for that individual. As for when it will update, I believe it should happen pretty soon after it's selected.
People started reporting today that they've started seeing updates in the SEVIS system with receipt numbers, like the DSO can see that in their system. Not for everybody, it's a slow process, but they just now started seeing that today. Praneet wants to know how soon you can get the H-1B stamp after you get the approval for this CAP season. So the earliest you can apply for a visa is 90 days before it takes effect. So I believe sometime in August is the earliest you can do that in order for you to get the visa for the October 1st start date. Just keep in mind, even if you get the visa early, you can't enter early. You can't use that visa. The earliest you could enter is 10 days before October 1st. Time for maybe one last question. I don't know if you have any good one on your side.
Let's see. So I have a question about someone in F1 OPT status whose spouse is, I assume, on H-1B because they're asking about changing to H-4 and the EAD, and how to time that and how to do it without there being any gap in work authorization. I would say for this person, it looks like you should be able to get it done without a gap in work authorization since your OPT is currently valid until 2020. You could go ahead and file the change of status now. Well, let's see. No, the I-539 won't be processed by then, will it? January 2020? I think it's, yeah.
You'd be cutting it close.
Yeah. The other option is going to be, like Emily mentioned earlier, traveling to apply for the H-4 visa stamp and then coming in on H-4 status. But as you know, there is likely going to be a gap in work authorization there because you won't be able to apply for the EAD card until you're back in the country in H-4 status, and then there's about a 3-month processing time. You can try filing the change of status now, but with the I-539 processing times, it may not be possible to avoid a gap. I would probably prefer the 3-month gap from traveling and getting the H-4 stamp and just waiting for the I-765. I feel like the I-765 will be processed faster than an I-539 right now.
All right. Well, I think that about does it for today. For those of you that have filed in the H-1B lottery, a lot of times they hear about their friends got selected and they haven't yet, or their employer says, well, I've gotten this many selected and I don't think any more are coming, so you must not have been selected. It's way too early to assume that. I do think more receipts are coming even for the advanced degree premium processing. So don't lose hope yet. There's still time. So just want to leave everyone with that. If we didn't get to your question, I apologize. You can always join one of our daily conference calls. It's very much just like this, where we take random calls and try to answer your questions. That's every day. You can get the schedule and the dial-in number by going to rnlawgroup.com. If you'd like to discuss anything in more detail with any of our attorneys, you can set up a consultation with any of us also by going to rnlawgroup.com. If you are looking for information on the H-1B cap and the lottery progress, you can go to immigrationgirl.com, where I update that information almost daily and answer your questions